Welcome to the Deep Dive. Today we are really digging into a major Supreme Court decision, one that just came down on June 27th, 2025, and it's already causing ripples, fundamentally changing how the federal government can even be challenged in court.
That's right. It's a big one. And this deep dive, we're focusing on the Supreme Court's ruling in these cases that, they actually started with President Trump's executive order on birthright citizenship.
Right, the order itself.
Exactly. But, and this is super important, the court's decision wasn't actually about whether birthright citizenship is constitutional or not. That wasn't the question they answered.
Yeah, that's a critical distinction to make right up front.
Yeah.
So our goal today is to really unpack what the court did rule on, why it's such a big deal, and what it means for the court's power to check executive actions moving forward. It's definitely complex, legally speaking, but we'll guide you through the key takeaways.
We will, so you understand what this shift really entails.
Okay, so to really get a handle on the court's decision, we need to start with that executive order, the one that sparked this whole legal fight. What exactly did it try to do?
Sure. So on January 20th, 2025, President Trump issued Executive Order 14160, or 14156, depending on how you track it, called Protecting the Meaning and Value of American Citizenship.
Okay.
And what it did, or tried to do, was deny U.S. citizenship to children born here in the U.S. if their mother wasn't lawfully present or was here only temporarily, and their father wasn't a citizen or a green card holder.
So very specific condition.
Very specific. It also told federal agencies, basically, stop issuing passports, social security numbers, those kinds of documents to these kids, and stop accepting state birth certificates as proof of citizenship for them. They gave agencies about 30 days to get ready to implement this.
Wow. And how does an order like that mesh with, existing law? Because birthright citizenship feels like a pretty foundational concept in the U.S.
It absolutely is. I mean, the idea of this is the right of the soil goes way back, English common law roots, and it's embedded in the 14th Amendment. Ratified back in 1868, the Citizenship Clause is crystal clear. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens.
Explicitly.
Explicitly. And that was specifically to overturn the Dred Scott decision, which had denied citizenship to African Americans. Then you have the Wong Kim Ark case from 1898, where the Supreme Court basically said, yes, born here means citizen, regardless of parent status, with only super narrow exceptions like kids of diplomats.
So pretty settled law for a long time.
Very settled. Legal scholars, even government lawyers in the past, like a 1995 Office of Legal Counsel opinion, called attempts to change this via executive action unquestionably unconstitutional.
Okay, so the executive order drops, seems to challenge this really established precedent. What was the immediate reaction legally?
Predictably swift. You had several groups jump in immediately: pregnant women who'd be directly affected, immigrant rights organizations, and actually a coalition of 22 states, plus D.C. and San Francisco.
Wow, 22 states.
Yeah, a significant number. They filed lawsuits pretty much right away in federal courts in Maryland, Massachusetts, and Washington state. The argument was straightforward. The order violates the 14th Amendment and federal laws.
And this is where we get to a really key part of this whole story. These district courts, they issued something called universal injunctions. Can you break down what that means? Why is that term so central here?
Absolutely. So a universal injunction, sometimes called a nationwide injunction, is when a single federal district judge issues an order that stops the government from enforcing a policy everywhere in the country, against everyone, not just against the specific people or states who filed the lawsuit.
So one judge can halt a policy for the entire nation.
Potentially, yes, at least temporarily. And that's what happened here. The district courts looked at the order, said it was likely unconstitutional, that the plaintiffs would face serious, irreparable harm, and that the public interest favored stopping it. So they issued these broad injunctions.
And the appeals courts agreed.
They did. The federal appeals courts upheld these preliminary injunctions. And it's worth noting, this practice, using universal injunctions, it's really taken off in recent years.
Oh, really?
Yeah, studies show something like 127 of them between the 60s and 2023, but like over 3/4 of those came after the George W. Bush administration started. So it's become a tool used against presidents of both parties, and frankly, it's frustrated both Democrats and Republicans when they're in the White House.
Interesting. Okay, so the Trump administration, facing these nationwide blocks, takes the case to the Supreme Court. But crucially, as you said, they didn't ask the court to rule on birthright citizenship itself.
Exactly.
They asked about the injunctions. So what did the Supreme Court decide on June 27th?
The court sided with the administration in a 6-3 decision. They significantly limited the power of lower federal courts to issue these universal injunctions. The majority opinion essentially said these broad orders probably go beyond the equitable authority, the kind of inherent fairness power that Congress gave federal courts way back in the Judiciary Act of 1789.
Okay, 1789. So they're reaching back pretty far. What was the core logic there? How did they justify saying these injunctions exceed court power?
The majority's reasoning was heavily historical. They looked at old English courts of equity and practices like bills of peace, which could resolve issues for scattered groups. But, they argued, those old tools were used for, small and cohesive groups, and the ruling bound all members of that group.
Okay.
Universal injunctions, they said, are different. They try to protect anyone affected by a government action, even people not involved in the lawsuit, and they don't necessarily bind those non-parties in the same way. The court said the modern way to get relief for a large group is a class action lawsuit under Rule 23 of the Federal Court Rules.
Rule 23, so specific procedures for class actions.
Exactly. Rule 23 has safeguards. You have to show the group is numerous, shares common issues, has typical claims, and is adequately represented. The court felt universal injunctions kind of shortcut that whole process. They also stressed that providing complete relief means fully helping the actual parties in the case, not necessarily every single person in the country who might be affected. Policy arguments about whether universal injunctions are good or bad, the majority said those were beside the point if there wasn't a solid historical legal basis for them.
Right, so it's about the scope of judicial power, rooted in history, not the policy itself. So what's the immediate practical impact on that original Birthright Citizenship executive order? Is it back in effect?
Partially. The court decided to partially stay the lower court injunctions. That means the executive order can now be enforced, but, and this is key, only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff with standing to sue.
Okay, unpack that a bit. What does complete relief to each plaintiff mean here?
It means the government cannot enforce the executive order against the specific people, the specific organizations, and the specific states who actually brought these lawsuits. They are protected, but for everyone else. The injunction doesn't necessarily protect them anymore. The Supreme Court sent the cases back down to the lower courts
To figure out
what narrower injunctions, tailored just to protect the actual plaintiffs, would look like. So the nationwide block is gone, but there will likely be specific, limited protections remaining for those who sued.
Got it. Now, a 6-3 decision means there were 3 justices who strongly disagreed. And they used some pretty powerful language in their dissent, didn't they?
They absolutely did. Justices Sotomayor, Kagan, and Jackson dissented forcefully. They called the majority's decision a grave attack on our system of law and even an existential threat to the rule of law. So, yeah, very strong disagreement.
Wow. Existential threat. What were their main arguments against the majority's view? They must have had a completely different take on history and judicial power.
Completely different. They fundamentally rejected the majority's historical analysis. Their view was that equity, the court's power to ensure fairness, isn't supposed to be frozen in amber from 1789. It's meant to be flexible, to adapt to new situations and new kinds of government action.
So history isn't static for them.
Right. They pointed to historical practices, maybe even those same bills of peace and things like taxpayer lawsuits, arguing they did sometimes offer broad relief beyond just the named parties. Justice Sotomayor really hammered the point that, in her view, the executive order itself is patently unconstitutional under settled law. And she argued that universal injunctions are sometimes a necessary tool, especially in cases like this, to protect vulnerable people, newborns, in this case from exceptional irreparable harm, and to make sure the government actually follows the Constitution everywhere, not just where it gets sued. Justice Jackson also pointed out that relying heavily on 1789 English courts maybe doesn't make sense for the unique American system, which specifically sets up courts to check the executive branch.
So, looking beyond the legal theory, what did the dissenting justices see as the real-world impact of this ruling? What does it mean for people, for you listening?
They painted a pretty stark picture. They argued this decision basically gives the executive branch a green light to enforce policies, even potentially unconstitutional ones, against anyone who hasn't personally gone to court and won their own case.
Creating a zone of lawlessness, as they put it.
That was the phrase, yes. They argued it particularly harms vulnerable groups, people who are poor, don't have lawyers, or maybe just aren't aware of their rights or how to navigate the legal system. They can't easily file individual lawsuits.
Right.
And they highlighted the practical chaos this could cause. Imagine a patchwork scheme, they said, where this executive order might be blocked in Maryland because the state sued, but fully in effect next door in Virginia because they didn't.
That sounds like an administrative nightmare.
Exactly. Huge burdens for people trying to get documents, burdens for agencies trying to figure out who the order applies to, and maybe even issues with federal funding for states caught in the middle. Justice Jackson argued quite powerfully that limiting the courts like this essentially gives the executive the go-ahead to sometimes wield the kind of unchecked, arbitrary power the founders crafted our Constitution to eradicate.
A fundamental challenge to the separation of powers, in her view.
Yes. She questioned how our whole system of rights works if you have to individually sue just to protect a right the Constitution already guarantees you, instead of the government being bound by the law from the start. And while, yes, class actions are still an option for broad relief,
But they're complicated.
they can be, as the dissenters noted, a drawn-out procedural bog was the phrase used, meaning significant delays and costs that might put relief out of reach for many.
Okay, so we have the majority focusing on historical limits and procedure, and the dissent focusing on flexibility and real-world impact. Were there any concurring opinions, justices who agreed with the outcome but maybe had a slightly different take?
Yes, there were. Justice Kavanaugh wrote a concurrence, and he emphasized this idea of the interim before the interim.
The interim before the interim.
Yeah, he was saying this decision is really about what preliminary relief district courts can grant in those first few weeks or months before the Supreme Court itself gets a chance to weigh in, often for what becomes a much longer interim period while the case is fully litigated.
So it's about managing that initial phase.
Exactly. He argued that for major federal policies, there should usually be one national answer on whether it can be enforced while the courts sort it out, and that deciding that national answer is typically the Supreme Court's job, not individual district courts. He agreed that a patchwork scheme, where a policy is on in some places and off in others, is unworkable and chaotic.
So he sees the Supreme Court as the necessary venue for that nationwide uniformity, even temporarily.
Pretty much. And Justice Alito also wrote a concurrence, raising some related concerns. He pointed out that issues like third-party standing, whether states can sue on behalf of their residents, and the whole process of class certification are still tricky areas. He kind of hinted that if lawmakers aren't careful about applying the rules for standing in class actions, those could still become loopholes to get broad relief, potentially undermining what the majority was trying to achieve here.
Interesting. So even among those who agreed on limiting universal injunctions, there are still nuances and potential future battlegrounds. Okay, let's try to synthesize this.
Yeah.
What's the big picture takeaway for our listeners? How does this decision really change the landscape?
I think the core takeaway is this represents a significant recalibration, maybe even a consolidation of power at the federal level. The Supreme Court is essentially saying, we are the primary body to decide on nationwide halts to federal policy, not individual lower courts. So, for you, the listener, this means a few things. First, challenging a major federal executive action and getting it stopped everywhere just got harder. You likely can't rely on a single judge issuing a universal injunction anymore. The path now probably runs through a more complex class action or directly appealing for emergency relief to the Supreme Court itself.
So the procedural hurdles are higher for broad relief.
Definitely. Second, it means challenges might become more fragmented. You could see that whack-a-mole scenario the dissenters warned about, where lawsuits pop up district by district, state by state, and the government might keep enforcing the policy against anyone who hasn't specifically sued and won. It puts a greater burden on individuals and groups to bring their own cases.
Making it potentially slower and costlier to achieve widespread protection.
Potentially, yes. And third, building on Justice Kavanaugh's point, it really elevates the Supreme Court's role as the key player in deciding whether a major federal policy stands or falls nationwide, even just in the short term while litigation proceeds. Lower courts have had their power significantly curtailed in that respect.
So we're left with this fundamental tension, are we? The executive branch's need to implement its policies versus the judiciary's role in ensuring those policies comply with the Constitution for everyone. This ruling definitely seems to shift that balance.
It certainly does.
Which leaves us with a final thought to consider. What does this shift really mean for how quickly and effectively potentially unlawful government actions can be challenged and stopped, especially thinking about people who don't have easy access to the courts, who can't afford long legal fights? Does this ruling fundamentally reshape how constitutional rights are enforced nationwide, making it harder to get broad, immediate protection? And what might the consequences of that be for future presidents, future policies, and ultimately for the American people?